There's an irony in discussing the Doe v. Reed case alongside Citizens United, because it's a good example of the fact that although the Supreme Court can typically be relied upon to pull some interesting decisions out of its sleeve, they often don't come in the packages that you think they will. When I first heard about Citizens United, I think I and many of the other folks who litigate in this area thought it was going to be yet another case, very much like Wisconsin right to life, where the Supreme Court might create some exceptions, kind of dance around the law, maybe hold that, you know, a film isn't covered by these laws, but, you know, we're going to continue this process of tinkering around the laws. Obviously, it didn't turn out that way. When I first heard about the issue at the root of Doe, it was in connection with Proposition 8 in California, where many of you are probably aware there were some serious actual, not just allegations, but actual evidence of harassment, using government disclosure laws to harass people who want to speak out about ballot initiatives. I thought, God, this is a controversial case. I mean, it involves one of the most controversial issues that we have today in gay marriage. There was actual evidence of harassment, and of course, when the decision came down, it had followed Citizens United by a few months. I think me and many other people were thinking, well, if the Supreme Court is prepared to allow corporations to spend as much money as they want on their own speech, surely it's going to jump to the aid of these people who are being harassed through the use of government disclosure laws. Alas, it didn't turn out that way. The Supreme Court in Doe, I think, issued a very narrow ruling. It is it's a ruling that, while is a very important ruling, and it's certainly one that I don't agree with, it is at least a predictable. It was much narrower than many people thought the court would go, especially in light of the Citizens United decision. Now, that's not to say that it's not important. It's not to say that I agree with the ruling. I disagree with it, and I'll talk a bit about why that is. But it is to say, as Ilya pointed out, which I say in my article, I think the decision is less important for what it actually did hold than for what it did not hold. What the court did do in Doe was to say that the states have the authority to require the public disclosure of petition signatures, the identities of the people who signed petitions, and their addresses to get an issue on the ballot. That's understandable to some degree, in the sense that even I, who is a staunch advocate of individual rights and smaller government, I even recognize that if we're going to have elections, we actually have to have laws that regulate the process of elections, to make them fair, to ensure that there's no fraud in the election process. I think most people agree with that. That makes good sense. The one question then becomes in that area, how far can the government go? When is it issuing a legitimate election process law, and when does it delve into an area of free speech that can chill speech? As I said, I disagree with what the court in Doe did, but I recognize that it at least has the authority, the government has the authority to regulate in this area. And I think what the court was doing was saying, look, we have to give some discretion to the states to decide how to characterize their laws. What the court did not do is go beyond that interest in ensuring against fraud, mistake, and managing the process of elections. And that was entirely appropriate, in my view. And speaking as somebody who litigates in this area against disclosure laws that chill speech, I'm very happy that the court actually did that. Now, that's an important distinction to draw, because it has an impact not only on the plaintiffs, obviously, in Doe, but more broadly on disclosure laws across the country in all of the states that allow citizens to vote on laws via the ballot issue process. To understand why that is, let me speak a little bit about the broader context and the types of laws that we have in this area. Now, I think broadly speaking, you can say that there are sort of two types of disclosure laws that apply in the ballot initiative context. The first is the one that was at issue in Doe. That is a law that regulates the process of elections, and the intent of which, or at least the putative intent of which, is to prevent fraud in the election process. That is, at least as the Supreme Court interpreted the law in Doe, that's what we were dealing with in Doe. One can take an issue with that interpretation. I do. I know Jim and his clients did. I don't really think the law could properly be interpreted to be serving the state's purpose in preventing fraud. But for purposes of the case, that's how the court interpreted it. So we take the court at its word, and now we look at how that decision will play out in the future. Now, the second type of law that exists in this issue is what I would call a broader, more general disclosure law. That's a law that requires anybody who spends money advocating the election or defeat of a ballot issue, or gives money to somebody else to do precisely that, now has to comply with a raft of disclosure laws, turn over their identity to the state, indicate how much they've spent on it, indicate sometimes, well, always their address, and oftentimes even their employer, simply to be able to speak out for or against a ballot issue. That's a much broader law. It has much graver implications, at least in the law, as a matter of law, for rights to privacy, rights to free speech, and rights to association. That's not to say that the impact on the individuals is any less. I think the impact on the individuals at issue in Doe was quite severe. It is to say, though, that the impact on the law, if we accept this other type of disclosure law, this broader disclosure law, then we might legitimately ask the question, what is left of privacy? After all, if the point of these laws, as the government argued in the Doe case, and as the states who have these broader disclosure laws have argued, if the point is to educate the public, the idea is if the public knows who's spending money to speak, really it comes down to who is speaking out, who is advocating one side or another in a ballot issue fight. If the public knows that, they'll be educated. They'll know more because they'll know more about the interests. They'll know about who else is lining up on each side of the debate. If we accept that argument, I certainly don't see how there is anything left to privacy at all. After all, anytime somebody wants to violate another person's privacy, what they are trying to do is, in effect, educate themselves about that person's private affairs. I mean, what's left over? If you say the state has an interest in disclosing your personal information, putting it on the internet because other people think it will educate the public, what's left that won't be disclosed? That's a very significant issue. It's an issue that the court didn't address. Thankfully, it didn't address that. That leaves open the field to argue this later on. And part of the reason that I say the decision is more important for what it didn't do is because, in my view, if you read the Doe decision, you come away with the feeling that the court was scrupulously avoiding saying anything about this informational interest, this idea that we can disclose people's private information to educate the public. I think that the justices avoided that entire debate and issue on purpose. That's not just the majority's decision. But all of the concurring justices and well, Justice Thomas in dissent attacked the entire decision. But even the concurring justices didn't really rely on this general idea that the government can compel you to disclose your private information when you wish to speak out. It certainly left that issue for the future. And I think, at least I hope, that the court will approach that with an entirely different take on the issue than it did in Doe. Now, Justice Alito, in concurrence, he concurred with the majority. He was on board with the idea that disclosure is appropriate to prevent fraud in the election process. He was not on board with the idea that we can go beyond that and require people to disclose their personal information because it might educate the public. Indeed, Justice Alito went as far as to say that the very idea that the states would have this power is, quote, breathtaking in its implications. As Justice Alito pointed out, if we can require people to disclose their funding sources, to disclose the individuals who are giving the money, simply to speak out, all they're doing here is speaking, then what can the government not require disclosure for? Indeed, if the idea here is to provide information to the public, why are we playing games with your address and your employer? That doesn't really tell anybody what you think. What we really need to be doing is finding out if you're a member of the NRA, if you're a Republican, if you're a Democrat, what religion you are, what your sexual orientation is, what is your ethnicity, where really in town do you live? Do you live on this side of the tracks or that side of the tracks? What's your educational background? That that's really going to tell us something about what people think. So if we are really serious about this idea of requiring people to disclose their personal information, even their addresses and their identities, for the sake of educating people who apparently are not educating themselves about the issues on a ballot issue, let's just cut right to the chase and really get to some meaty information. That's essentially what Justice Alito is saying. Now, this is breathtaking, or at least I hope it is. It certainly is to me. And as Justice Alito pointed out, it would really disrupt or overturn not only decades of First Amendment jurisprudence, but a tradition of privacy, anonymous speech, and anonymous association. It goes all the way back to the founding era. I mean, the Federalist Papers, after all, they were speaking anonymously. There are many, many, many other examples of anonymous speech and privacy in one's association when one is agitating for a political cause. This makes sense, both from a doctrinal standpoint and from a practical standpoint. Typically, people who are agitating for political change are going against the grain. There's an incentive for those who are opposed to them, oftentimes the majority or factions, to try to ferret them out so they can criticize them and intimidate them in public, try to prevent them from speaking, right? That actually happened with the NAACP during the 1960s. Whatever you think about the gay marriage issue, I'm actually in favor of gay marriage, but I am also in favor of people speaking out and maintaining their privacy and not being intimidated when they do. Thankfully, the Supreme Court, as it were, didn't go there, and I think many of the justices purposely avoided that issue, either because they have serious concerns about it, but in any event, narrowed the issue in Doe strictly to the state's interest in maintaining the integrity of the elections and preventing fraud. So in a sense, we live to fight another day if you're on my side, but in any event, to determine really what will play out and how this issue will play out in the future, we're going to have to wait for a future case. Now, I think I'd be remiss if I didn't quickly mention what I think the court should have done in Doe. I agree ultimately with Jim Bopp's position, but I think one can do certainly worse than relying on Justice Thomas. Justice Thomas dissented in the case, and he really had a very common sense take on it, one that I think was absolutely right, and I always admire Justice Thomas for cutting right to the chase, pushing aside all of the nonsense. His basic point was this: look, first of all, there are a lot of people here who want these signatures not because they're going to go home and scour through the rolls and compare them to voter registration and say, aha, this person's not actually, a registered voter, so we need to strike them off the list. No, of course not. We knew from Proposition 8 in California that a lot of the reason for getting these signatures was precisely to harass these people. The state digitizes signatures already. It can put them in a computer database, compare them to the voter registration rolls, voila, problem solved. It's really not that complicated. We live in an age of technology. If the state wants to check against fraud, it can do so. Therefore, the state can't go beyond, even in the exercise of its authority to maintain the integrity of elections and trench on people's privacy. Once again, Justice Thomas got it exactly right. Justice Alito also hit the nail on the head in criticizing the information interests. So I at least hope that in the future the court will do the right thing and protect people's privacy, their right of association, and free speech. Thanks very much.